In today's lecture, I'm going to cover case law in the early civil rights era. Now, the civil rights era is an extremely large topic, so I'm going to have to break it down into chunks to even give a basic overview of the sorts of things that happened. Let's start by setting the stage. So, first of all, remember there's a couple of things that happen after Reconstruction that put in place the situation in the South and also in some cities in the traditional North and Midwest that we call Jim Crow. And these Jim Crow, which is called de jure segregation, which means segregation enforced by the law. And so, because of this segregation, we see the civil rights movement as a reaction to that. So, first of all, Jim Crow laws were established in the South beginning in the late 19th century. These are segregation laws. Black people were not allowed to use the same public facilities, live in some of the same towns, go to the same schools. Interracial marriage was illegal, and most Black individuals couldn't vote, especially in the Deep South, because they were unable to pass different literacy tests. Moreover, in 1896, the United States Supreme Court granted the Plessy versus Ferguson decision, which enforced separate but equal, and that remained the law of the land until Brown versus the Board of Education, which will be the last topic we talk about here today. Um, there is some effort during World War II to try to end segregation in some way, shape, and form. FDR issues an executive order in June of 1941, which opens up national defense jobs and other government jobs to all Americans, regardless of race, creed, color, or national origin. Remember, the president can do all these things because the president is the commander in chief of the armed forces and does not need the backing of Congress to do so, which he probably wouldn't have gotten. The Tuskegee Airmen were the first African Americans to break the racial barrier in the military, becoming the first Black military aviators in the U.S. Army Air Corps. And they earned more than 150 distinguished flying crosses. As the Cold War began, President Harry Truman initiated a civil rights agenda, and in 1948 he issued Executive Order 9981 to end discrimination in the military. So discrimination in the military was now illegal. That doesn't do everything, but it certainly does something to start to move the ball in the right direction. And these are the events that start to set the stage for the grassroots initiative to enact racial equality legislation and incite the civil rights movement, part of which we're going to talk about today. Now, as we turn to these cases, one organization that is going to be central to all of this is the NAACP, or the National Association for the Advancement of Colored People, founded in 1909. For about the first 20 years of its existence, it tried to persuade Congress and other legislative bodies to enact laws that would protect African Americans from lynching and other racist actions. That's not successful by and large. So they turned to another branch of government, the judicial branch. So early on, throughout the mid 20th century, the NAACP is going to be involved in a legal strategy to bring down Jim Crow through the courts because it's unable to do so because of the power of the Southern voting bloc in Congress. So what it tries to do is it files cases in an effort to chip away. And let me explain this strategy a little bit more because it is important. They really want to try to do two things. First, using the sort of separate but equal theory, the NAACP is going to try to make segregation prohibitively expensive. What I mean by that is if separate but equal is true, then there should be a Black school next to a white school, and they should be exactly the same. There should be a Black college next to a white college, and they should be the same, and so on and so forth. Excuse me. So, what that means is if you can force these different organizations to have two of everything, you make it impossible for them to continue to have segregation. But the other thing that they're really trying to do is get a decision that says separate can never be equal. In other words, the idea of separate is inherently, and we'll see that word again, unequal. It's part of its being. So there's no way that you can ever actually achieve this. That's their ultimate goal. They want rulings in that favor. So there's a couple of cases. I'm just going to walk you through the basics of some of them. Most of these cases refer to law schools and graduate schools and the attendance thereof, because most states had colleges for Black individuals and for white individuals, but in many of these states, the post undergraduate institutions, the law schools, the medical programs, the graduate programs, were whites only. So there wasn't an option for Black individuals. So this is why the NAACP decides that they're going to attack in this angle, because it makes so much sense for them. So, back in the 1930s, the University of Maryland School of Law rejected all applications of Black individuals on the basis of their race. So, in 1935, a man by the name of Thurgood Marshall, who's the most important NAACP attorney, brings a claim on behalf of a man named Donald Gaines Murray, whose application to the University of Maryland School of Law was rejected on the basis of his race. The Maryland School of Law position was basically that there are other law schools that he can go to. So therefore, we don't have to admit him into this one because there are separate institutions. Marshall argued that that may be the case. However, there weren't any institutions of the same caliber, of the same quality. And so, even if they were separate, they weren't equal. And so, the only remedy that would work here would be to allow Mr. Murray to attend the University of Maryland. The Baltimore City Court agreed. So did the Maryland Court of Appeals, which also ruled in his favor. The law school was forced to admit him, and 2 years later, he graduated with a law degree. In Missouri ex rel Gaines versus Canada, here's where we're talking about another law school. In this case, it's the Missouri Law School. This one's a little bit different because the University of Missouri is so intent on making sure that Mr. Gaines does not attend their law school that they decide that they'll pay for him to go to a different law school in a different state. In this case, again, Marshall argued that might be separate, but it's not equal because it's very inconvenient for this person to have to travel to a different state to attend a law school when there's a perfectly good law school right here. And once more, the court found itself agreeing and was allowing Mr. Gaines to go to this university for the reasons that I already stated, because it was not an equal situation. They had to let him in. In Sweat versus Painter, this is another law school, and this one's the University of Texas, all-white law school. Now, Southern State tries something different in this case. So we tried to send him to a different state for education in the Gaines case. In this one, in 1950, they say, that's okay. We're going to build a Black law school next to the white one. So in only a couple months' time, the state of Texas throws up this, rickety law school for Black individuals that may or may not have any faculty into it. Here, the United States Supreme Court once again struck down that idea and agreed with Thurgood Marshall, who's the lawyer in basically all of these, and said, no. This hastily erected school for Blacks is by no way equal to the one that exists for whites. It just can't be. It doesn't have the prestige. It doesn't have the faculty. It doesn't have any of the facilities. So once more saying, yeah, you built another one, it's separate, but it's not equal. So we're not going to allow that. At the same time, we have a case called McLaurin versus Oklahoma. This one is different. So Oklahoma, in its graduate program, so we have George McLaurin. He's trying to get his doctorate. He's admitted to the University of Oklahoma, but you can look up pictures of this, by the way. It's really bizarre. They sort of build him his own room within the classroom. So if you see images of this, what they do is they take the lecture hall that all the white students are, and then you see this like box in the corner. So they have Mr. McLaurin sit in this box, and then they sort of build it around him so that he's kind of separate from everybody else. They build him his own little cafeteria, and they make him go there by himself, and so on and so forth. So it's really strange. But ultimately, the Supreme Court rules that no, you can't do that. Okay, yes, it's the same school, we get that, but it is so detrimental to this individual's mental health to force him to sit in a box during a lecture hall, where that is might be separate, but it's certainly not equal. And that brings us to the big guns. Brown versus the Board of Education. Brown versus the Board of Education is the name given to 5 separate cases that are merged concerning the issue of segregation in public schools. Once again, Thurgood Marshall and the NAACP handled these cases. The case involves a young woman, her name is Linda Brown. She is allowed to go to school, but she has to take a bus for miles to attend a elementary school, even though there is a whites elementary school that is directly up the street from where she lives. She files a lawsuit and ends up before the Supreme Court in 1952, arguably one of the most important court cases of all time. So the issue on appeal was, are separate schools based on race, what they say, inherently unequal? So that was the phrase that Thurgood Marshall used, which means they simply are automatically unequal. There's nothing you can do. They could be identical schools with identical faculty. Everything could be exactly the same, and they're still unequal. Why? Thurgood Marshall argued because people are going to know why they are being separated. And so there is a brand of inferiority that ends up violating the Equal Protection Clause of the 14th Amendment to the United States Constitution. This is an interesting case because there's actually a lot of science in this case for the first time. There's a series of psychological tests performed by social scientists, and these become evidence in the case for an argument that these segregated school systems made Black children feel inferior to white children. And this evidence shows why that this system should not be legally permissible. Now, the justices of the Supreme Court were deeply divided over these issues. Most of them at this point did want to reverse Plessy versus Ferguson. And this case was the first time that the NAACP is asking outright to overturn the idea of separate but equal. But they couldn't come to a final decision. So you need a majority, 5-4, on the Supreme Court to issue a decision. They try to do it all throughout their term, and they can't. So the end of June 1953 is the end of the court's term. So every year there's a court's term, then they go on what's called recess. Now, the court decides then to rehear the case in December 1953. During the intervening months, however, something very important happens. The current justice of the Supreme Court was a guy by the name of Fred Vinson, and he dies in this intervening period. He's replaced by Governor Earl Warren of California, who becomes Chief Justice on what is referred to as the Warren Court. The Warren Court is one of the most judicially active courts in the history of the United States. Governor Warren's an interesting person. He was appointed by Eisenhower, a Republican, and was thought of as a conservative man. But he's one of those people one of the rare people who seems to undergo a little bit of a change once he becomes part of the Supreme Court. And a big part of this is that during World War II, Governor Warren was a major part of Japanese internment camps in California. So they took people of Japanese descent, and they put them in internment camps throughout the war for fear that they were going to sabotage the United States. There's no evidence of this, but that was their fear. That experience seems to have really changed Governor Warren. And so after the case was reheard in 1953, Chief Justice Warren was able to do something that Vinson wasn't able to. He was able to get all the justices to agree to support a unanimous decision, 9-0, declaring segregation in all public schools unconstitutional. And so, on May the 14th, 1954, the Supreme Court, in a unanimous decision, overturned Plessy versus Ferguson, declaring, quote, "We conclude that in the field of public education, the doctrine of separate but equal has no place." Now, it's all well and good, of course, for the court to declare this, but as we'll talk more about next time, it's a whole nother issue to get this to happen. But let's just look at schools really quickly. The biggest example of an attempt then to integrate a school is the case of the Little Rock Nine, which, as you can see by the date, is in September 1957. So it takes 3 years for someone to really make an actual effort to get this to happen. The Little Rock Nine were a group of 9 black students who were enrolled at the formerly all-white Central High School in Little Rock, Arkansas, in September 1957. Their attendance at the school was a deliberate test of Brown versus the Board of Education. On September 4th, 1957, the first day of classes, the governor of Arkansas, his name's Orville Favis, if you'd like to know, called in the Arkansas National Guard to stop these black students from entering into this high school. Later that month, the president at the time, Dwight Eisenhower, would send in federal troops to escort the 9 Little Rock students into school. This is going to be one of those ground shed moments that it's going to just get a lot of attention to the civil rights movement. The 9 students were Minea Brown, Elizabeth Eckford, Ernest Green, Thelma Mothershed, Melba Patio, Gloria Ray, Terrence Roberts, Jefferson Thomas, and Carlotta Walls. And these were 9 people, by the way, who had been recruited by the Arkansas NAACP as good test students. They were carefully vetted, and they were determined that all of these 9 students had strong character and would be able to face the resistance that they knew that they were going to encounter. They just didn't know how much they were going to encounter. So the Little Rock Nine shows up for school on that first day to try to go in. And of course, they're prevented by doing so by the National Guard. Interestingly enough, 8 of them come together. However, Elizabeth Eckford, who's actually shown on the image that's there up on the screen, didn't have a telephone, didn't realize that people were carpooling. And so she was shadowed by this crowd of individuals who shouted insults at her and spat upon her, did all number of things as she walked to school. It's one of the most enduring images of the civil rights movement. And unfortunately, even after they got into the school, things didn't get any easier for the Little Rock Nine. Melba Patio, for example, was beaten, kicked, and at one point had a vat of acid thrown in her face, but still was able to get through. The reaction to the forced integration of the Little Rock school system was not good, to say the least. In September 1958, the governor there decided he would just simply close all the schools in Little Rock pending a vote. And then by a vote of 2-1, citizens in Little Rock voted to close, in this case, all their high schools rather than integrate. So Little Rock chose to keep all of its high schools closed for an entire year. They reopened in 1955 rather than allowing them to be integrated. So this is just the beginning of a look at the civil rights movement, but it does give you a feel for the steady steps and progression that the different leaders are going to go through in order to try to reverse what is going to be centuries of discrimination throughout the South.